Okay, we're looking good. So I think what we'll do is we will formally get started. Thank you, everybody, for attending this presentation. It's a joint effort between three firms. It's my law firm, Falcon Rappaport Berkman. It is Intention Wealth Management, which is affiliated, of course, with Northwestern Mutual. And it is the law firm of Shenwick and Associates. I will turn it over to my co-panelists to introduce each of their respective companies. But in the interim, I'm going to make some opening remarks, first and foremost. This presentation will be available on recording. So if you would like to get details about the recording in order to be able to share this freely with others, we are happy to have you do so. You may contact FRB's Director of Marketing, Abby Winkler. Special shout out to Abby for helping us put this presentation together, for helping compile the materials, for helping to coordinate and herd all the cats. We are very appreciative of this. So we, first and foremost, will have this available on recording. Second, I should go ahead. What kind of lawyer would I be anyway if I didn't go over the standard disclaimer? So the presentation is general information, even though you have two lawyers on this panel. This is not anything that gives rise to an attorney-client relationship, even though you have a financial advisor on this panel. Nothing that you see today is financial advice. And there is a whole slew of disclaimers that Mr. Borow is going to go over when it is his turn to introduce himself. But in addition, there will be no legal or tax advice disseminated on this presentation. If you are to implement any of the concepts that you hear today, you are only to do so with the assistance of competent counsel, preferably us. And by us, I mean that collectively. I mean FRB, and I mean Jim, because Jim practices areas of law that we do not cover here. So hopefully we'd be able to work together in tandem for you. But one way or another, if you are going to implement any of this, please do retain a competent advisor to work with you. And finally, there is no intention here to market or promote any transaction plan or arrangement as those concepts are defined in IRS Circular 230. Let me formally introduce myself for a second. I promise not to have this too prominently up in front of you, because if you stare at my face too long, you'll turn to stone. But that's me. This is a description generally of what I cover in my areas of practice. I'm a tax lawyer. So my expertise is in the law of taxation. It is primarily in two areas, income taxes and estate and gift taxes. Those are rather broad headings, so I'll get into very tiny details about what I cover in particular. I cover real estate taxation. I cover taxation related to closely held businesses. I cover taxation related to private equity firms and some stuff related to executive compensation. I do stuff with opportunity zones, 1031 exchanges. I do stuff with generational wealth transfer. I do stuff related to mergers and acquisitions and helping out corporate and other transactional lawyers when it comes to implementing stuff that requires tax expertise in order to do correctly. Even though we are ourselves a law firm, we play well in a sandbox with other law firms. So do feel free, if you're a lawyer, to reach out to us if you'd like to work with us to have us fill in some of the gaps where you feel you might need some supplemental expertise in order to implement the stuff that you want to do, or to take on larger work, or whatever else you think would appeal to you. We also work well with accountants. We work well with financial advisors, with bankers, and with folks that are in a select few other areas of professions, including qualified intermediaries for 1031 exchanges. So with that out of the way, let me turn now to Mr. Shenwick. Jim, introduce yourself and your firm.
Good morning, everyone. Shenwick and Associates. Our areas of practice are personal and business bankruptcy, workouts, and asset protection planning. Unfortunately for clients, these have been very busy times. We've been handling a lot of restaurant and retail bankruptcies and workouts. Prior to that, taxi medallions. We work with accountants and lawyers. It's a specialized practice area. In the asset protection area, we're typically the second attorney that is called. The client gets sued, they're served with a summons and complaint, they call their litigator, and either the client or the litigator will bring us in to do asset protection planning, to threaten a bankruptcy, or to attempt or assist the client in doing a workout. I also have an LLM in tax from NYU, although the main focus these days we deal with legal indebtedness income is workouts and bankruptcy filings. And Matthew and Scott, thank you very much for including me this morning.
Jim, your audio is fading in and out as you introduce yourself. So I just want to make sure I'll alert you to it if it happens later on in the program.
Thank
but
you.
I just wanted to let you know there was a little bit of fading. It's, if you listen closely enough, you can make out what you're saying. So it wasn't awful, but it was fading out to the point where you sounded like you were coming through talking through with like cans to the tree houses, you know what I mean? Cans on string to the tree houses.
Let me,
Anyhow, what did I do here? I reset the presentation. That's no good. Okay,
let
Scott,
me,
Jim, were you going to go ahead and check on your audio?
yes. So is it better now?
It is. So if it's just a matter, I think, of you becoming closer to the microphone, it might
Yes.
be yeah, it might be good to go ahead and adopt that as an ongoing stance, because whatever you're leaning away, it sounded like you're fading out a little bit.
I'm there. All right.
Okay,
Let's
so
hear Scott. I got it.
glad we got that going. Okay, and Mr. Borow.
Thank you, sir. So my name is Scott Borow. I'm a wealth management advisor here at Northwestern Mutual. I am one of probably the 5 to 10% of advisors at Northwestern Mutual who has been allowed to co-brand with Northwestern. I work, my niche has been physicians. I'm known throughout Northwestern Mutual as one of the top advisors working specifically with physicians. But with that being said, I have a practice that covers not just physicians, business owners, lawyers, as well as individuals in finance. So I also, an increasing area of concentration would also be technology. My areas that I really cover, I really cover from a kind of a big picture. If you think of me as the quarterback on a football team, I'm going to be throwing passes to tight ends, to running backs, to wide receivers. But my firm particularly is known for its ability to set up disability life insurance. But I personally, my practice is focused in on wealth management, financial planning, from retirement, education for kids, estate planning. I also do business planning, setting up retirement plans, health insurance, and other individual types of plans. And that's really where my expertise lies. I have a team of two, in addition to myself, that work with me. They are arguably the harder workers and arguably the core of my practice. So in addition to speaking with me, you'll probably end up speaking with one of the two of them, as they're the ones who really are going to be the ones to help you the most.
Fantastic. Okay. So just to set the stage a little bit before we jump into this, right? I'll introduce the concept of asset protection, and then what I'm going to do is I'm going to turn it over to Jim right after that to discuss fraudulent conveyances and how they might affect people who have creditor problems. And the cool thing about having Jim here, because I know that there was some audio cutting in and out as he was introducing himself, is that Jim's concentration in the areas of bankruptcy and general things having to do with the debtor-creditor law gives us a perspective that, for those of you, because I see on the attendee list for the live part of the presentation, there's some people here who have seen our deck on asset protection before. But the twist that we have today is that we have an attorney who's familiar with debtor-creditor issues and with the bankruptcy process. And that is going to be a major plus, because some of the stuff that we're going to go over today is going to have to do with, hey, what happens in a worst case scenario where you have a person who has built up all these assets over time and they may come into jeopardy in the event that there's a controversy, and the controversy results in a judgment, and all sorts of other horrible things cascade after that. So that's the perspective that Jim is going to bring, because as I mentioned, FRB doesn't do debtor-creditor as a concentration. It doesn't do bankruptcy as a concentration. So adding that element, I think, is going to be very big. Our focus today, even though a lot of this stuff is generally and universally applicable, today is going to focus on the medical profession. It's going to focus on doctors. Why? Because as Scott and I have collaborated, that has been where we have burrowed down the most. And what we've confronted is, it seems to be a universal concern on every doctor's mind. Every medical professional turns around and says, but what if, right? Understanding the concept that all lawyers are bad people. What about a plaintiff's lawyer coming after me and trying to seize the assets that, as a hardworking doctor, I've built up my entire life? And we're really going to focus today on the medical profession and what can doctors and registered nurses and other sorts of people who are affiliated with that field do in order to protect themselves. So let's begin by introducing the concept of asset protection, right? Generally, what you're looking to do is you're looking to put assets out of the reach of creditors while maintaining some indirect ability to enjoy the assets as you would if you owned them directly under your own name, effectively. And the art of asset protection is to make sure you are strictly observing the legal and the financial and in certain cases the tax tenets of setting up vehicles to make sure that in the event the worst happens to you as an individual, these assets are going to be out of reach, preferably, or if they're within reach, they're only partially within reach. Something in order to make sure that a creditor can't simply come in and take the assets that you may have built up and seize them. But there is, as I mentioned, a great art to this. There is a framework that Jim is going to start going over in a second. There's a framework that revolves around between the bankruptcy code, the internal revenue code, the debtor creditor law, the estates powers and trust law, and a few other things under both state and federal statutes that are going to determine whether or not the asset protection is effective. There are judgment calls to make along the way. There are certain trade-offs that you may have to make, and those are the things that we're going to describe. So jumping right into it, where we're going to begin, and I'm like, I got the itchy trigger finger over here. So this is the proper slide, by the way, fraudulent transfers. Jim is going to take it from here by going over the concept of what is a fraudulent transfer? How do you determine whether a fraudulent transfer has occurred? How do you avoid making one? What happens if a court finds that you have made a fraudulent transfer or fraudulent conveyance? And Jim, with that, I will turn it formally over to you for this next segment.
Thank you, Matthew. So good morning, everyone. Let's talk about fraudulent conveyances. Fraudulent conveyances are a bankruptcy law concept and a state law debtor-creditor concept. Now, I'm going to give you Jim's back of the envelope definition of a fraudulent conveyance. Here it is. A fraudulent conveyance, and I was just speaking with a client about that this morning, is a transfer to a third party, a family, a friend, a spouse, a child, a fraternity brother, any third party for no consideration, i.e. a gift that leaves the transferor with inadequate capital to run their business or to pay their ongoing or prior debts. Again, in more of a thumbnail, it's a transfer for no consideration that leaves you with inadequate capital or money to conduct your affairs or to pay your bills. Here's the scenario. An individual gets sued for one reason or another. They don't have adequate insurance. They basically panic. They speak to their brother, their sister, their parent, and the concept arises, well, you're going to be sued or you're sued. The creditor may obtain a judgment. Let's make you judgment proof by transferring away your assets for no value, meaning gifting them away to make it more difficult for the creditor to collect. Now, there are legal ways to do this, and there are illegal or improper ways. A fraudulent conveyance is an improper transfer. It is not criminal, notwithstanding the words fraud, and the look-back rule is generally 4 to 6 years, and in a bankruptcy, the heavily scrutinized period is generally 90 days, 1 year, and 2 years from the date of the transfer. Now, as we're going to see in the next slide, fraudulent conveyances are bad. You, the transferor, and the recipient of the transfer can be sued by the judgment creditor or the bankruptcy trustee, and the transaction can be reversed. There could be legal fees incurred and other penalties. And one other point that isn't on the slide is that if you make a fraudulent conveyance transfer, you're not eligible for a discharge in a Chapter 7 bankruptcy. So fraudulent conveyances are to be avoided at all costs. Matthew, next one. Great. How do we determine if a client has made a fraudulent conveyance? I always ask for a balance sheet. That's a schedule of assets and liabilities for the individual or for the company. That could be an LLC or a corporation. I ask, what was the consideration? In law school, they teach you arrows pointing each way. Here's the item was transferred. What did you get back for the transfer? If there's no money or property or the assumption of debt, a liability, then that would be a gift, and that is a sign of a fraudulent conveyance that could be reversed. Now, badges of fraud. Matthew, one more. Next slide. There's no, this is, think of it as a checklist. This is what a judge, creditors counsel, or a bankruptcy trustee will look at to see if there are indices of a fraudulent conveyance. Was the transfer to an insider? An insider is generally a family member or a business partner or people that are involved in a joint venture. Did the transferor, the party that made the transfer, retain control of the asset transferred in some way, directly or indirectly? Was there concealment, meaning was the transfer disclosed? In a bankruptcy petition, bankruptcy filings are based on full disclosure. There's supposed to be transparency. If there was a transfer, was it listed? Did you indicate who the transfer was made to? Similarly, if you're deposed in a lawsuit, did you lie? Did you make a false statement when you were under oath? If you did, that could be perjury and potentially it could be criminal. Okay, now 4 is the gathering storm, meaning were you aware, had you been served with a summons and complaint? Did you know you were going to be doing a bankruptcy filing, or did you just wake up one morning and say, this would be a nice time to make a transfer? Next point, solvency. Solvency in bankruptcy and in debtor-creditor law is based on your assets and liabilities. If your assets are greater than your liabilities based on fair market value, you're solvent. If prior to the transfer or after the transfer, your liabilities exceed your assets, then you're deemed to be insolvent. Solvency can also have another definition based on cash flow. Do you have the earnings or the income or the dividends from a stock portfolio to pay your creditors? If you don't, you may be deemed insolvent. Timing of debts, we've talked about this. The worst time to do a fraudulent conveyance or a transfer is after you've been sued. If you want to make transfers, the best time to do it is as early a date as possible.
Jim, I'm going to step in with one last point on that number 6. I get questions a lot in terms of if I make a transfer and I have outstanding indebtedness with a personal guarantee, happens often in real estate, can the creditor come after the assets if they're subsequently transferred? Besides the idea that this would be possible regardless of circumstances, because of the idea that you own the asset and it was within your own dominion at the time that you incurred the debt. A question I often get is, or rather the question I ask back is, was this asset on a personal financial statement at the time that you represented what your own worth was when the lender asked for it? And if it showed up on the PFS, the personal financial statement, they're going to have the equitable grounds, if not the outright legal grounds, to go after that asset regardless of a subsequent transfer. Because the argument's going to be, Your Honor, we lent money to this person, and that person, their creditworthiness on a personal guarantee was based on the disclosure of this asset on a personal financial statement. So the fact that they don't have it anymore should be material in determining whether or not the asset should be yanked back into their ownership and considered as part of either a bankruptcy estate or generally available to creditors if there is no bankruptcy going on. But I say it to a lot of people. What you may be able to do, and Jim, I'm interested to hear your thoughts on this, you may be able to take something disclosed in a personal financial statement and shield it from creditors other than that one. So if you have a institutional lender A who says, I want your personal guarantee on this loan to fund your real estate project, and you disclosed asset B on a personal financial statement, you can take asset B, potentially put it into a trust. As to the other creditors, maybe you'll be able to protect it from any other creditor you could not have foreseen at the time of transfer. However, you can't protect that asset from institutional lender A. It's basically that lender is always going to be able to turn around and say, no, 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 we had that asset disclosed to us. It was part of our valuation. Jim, would you agree with that?
So first of all, you've raised an interesting question, Matthew. Not only will, in my experience, not only will lenders or judgment creditors look at personal financial statements, they'll also request insurance policies to see what property or assets you insured. Now, with respect to that asset, it may depend on what the loan documents say about no transfer, no conveyance, no using that as collateral for another loan. But the point is a good one, which is if you disclose an asset and then transfer it, that could cause an issue with the lender. And then you raise the issue of a guarantor. Not only would you be liable, but the third party guarantor could be liable if there was a deficiency and the loan was not repaid.
Excellent. Okay, moving on here. Let's talk about timing, Jim.
Okay, so good question. The first point is with respect to the creation of a trust, which could lead to a fraudulent conveyance, the bankruptcy code allows a 10-year look back. Under New York debtor creditor law, the typical look back is 6 years. My experience with bankruptcy trustees is they only look back 2 years. A typical judgment creditor with an experienced litigator will generally look back 6 years. And now with a recent new law, the look back may go 4 years. But to answer the question, the key period of time could be as long as 10 years.
Okay. Yeah, this is, let me step in here and talk about what can happen if you have a fraudulent conveyance against the government, because I've seen this now. I've had people approach me probably half a dozen times in the last 2 years or so, right? Ever since the start of COVID. I had a couple of gentlemen approach me, say, we're anticipating an indictment from the Department of Justice over potential matters that we have with a certain government agency, okay? The reason why, as an advisor, you do not want to get involved in these situations, right, is because you can personally be held liable as the advisor to a transfer. That's a fraudulent conveyance against the government, right? It happens in those contexts. It also happens in a tax context, okay? Now, that's covered in the Internal Revenue Code, Section 7206. You got a $100,000 penalty and or 3 years in prison. Nobody wants to get caught up in this. I mean, you're talking about the potential loss of your livelihood, not to mention whatever assets you may have built up. So generally, the advice that I give folks who are in hot water with government agencies is, do not make this worse, okay? What I often tell people is, regardless of the agency with which you're in hot water, you're going to be able to find a very, very expensive lawyer who drills down specifically in the matter that you're facing, even if it's criminal, okay? And what you're going to be able to do is have that person communicate with the agency where they likely used to work, okay? The fact of the matter is, I had a matter once where I had somebody who was in hot water with Health and Human Services. Who was their lawyer? Former Health and Human Services with the particular agency that they were in trouble with, okay? And what they were able to do is they were able to communicate with people they had worked with previously, and they understood how to navigate the system. You throw fraudulent conveyance against the government on top of that, and nothing's going to go well for you. Nothing. Jim, you want to touch briefly on fraudulent conveyances in connection with a bankruptcy?
Yes. So I want to dovetail off your point, Matthew. It's a good point. A bankruptcy petition is filed under penalty of perjury. When you go to the hearing room, when you meet with the bankruptcy trustee, now they're done telephonically, there's a big sign that says the FBI and the Department of Justice investigate bankruptcy crimes. Not many people do this, but if you file a fraudulent bankruptcy case or you do not disclose assets, a referral could be made to the Department of Justice and the FBI, and that could be criminal. In a civil context, the bankruptcy trustee will commence a lawsuit. I got referred a matter this morning that I'm working on for a a firm that funded litigation and a bankruptcy trustee is suing them for fraudulent conveyances. So the answer is, if you do an improper fraudulent conveyance, you're putting a target on your back.
Right. Nobody wants one of those. I'm throwing it to Scott for 1 second because I want Scott to comment on his work with the medical community. All right. And I want to have Scott talk about what specifically, given that Scott has a very high concentration of doctors and other medical professionals as clients, I want Scott to talk about the particular things that are on the mind of a medical professional when they think about asset protection, and in particular, commenting on the idea that you can have malpractice liability insurance, but at the end of the day, there are scenarios in which that alone may not be enough. So Scott, take a moment here, talk about your work with medical professionals and what their typical asset protection concerns are.
So one of the things that I've noticed that have changed significantly in the medical community and with very much hospital-based medicine is that a lot of the hospitals, especially in New York, are going towards self-insurance. So the malpractice, they have self-insurance. So as an upside, when one of the physicians typically gets sued, what ends up happening is because you're doing consults for a lot of different cases that you may not actually be practicing on, most of the malpractice attorneys are going to go ahead and they're going to launch the suit against every single person. So a lot of times, even if you didn't make a mistake within the case, you're dragged into it. Now, on one end, that because of the high concentration or frankly, the awesomeness of someone being sued, I joke with one of my good clients that, you don't make it out of residency as an OBGYN in New York without getting sued at least once. And if you do, congrats, it's like a rite of passage. But, I guess and not to make a joke of it, but the running joke is that it's just so more common that it's become very much top of mind to all the physicians I work with. When we're looking and we're going through in terms of assets, so the two questions that we ask, and Matt, on a particular case that we did, this kind of came into play of, do you think potentially that you can be sued above the limits of what it is that the hospital is going to back you for or what your malpractice covers? But one of the things that I've also seen that is actually less, from my experience in working with physicians, they see the issues at their job, but what they don't see is what happens outside. The car accidents, someone slips and falls, the protection of your assets outside of the liability you have at work. That very often is one of the biggest sources of potential asset protection that needs to happen. For example, if you drive with MD plates, higher likelihood to get sued. If you have a doctor sign hanging outside your home or your practice, more likely to get sued because obviously doctors, it's affiliated that you have more money than the average person. So those are some of the thoughts that, from my experience working with physicians, that they're thinking of on a constant basis. Now, in going through all this, the one thing, and not being a lawyer, but listening to James and yourself, Matt, go through this, the one thing I'm thinking of is, looks like you need to set your assets up before this becomes an issue.
Agreed.
Yeah, there's no question. It's the old adage, the best time to plant a tree was 10 years ago. The second best time is now. Also works in investing, right? So you can think of asset protection the same way you think of investing. Scott, this is another good opportunity for you to step in for 2 minutes. Can you talk about the idea that in both asset protection and in investing, doctors are so busy working on their practice and making sure that they are up to the latest cutting edge standards of medicine, reading studies, honing their craft. Certain of them are doing surgery, certain of them are in there doing medical research and all these other things. You're concentrating so much on a very important calling that you're forgetting a lot of these peripheral things that don't necessarily make you a better doctor. Right? I mean, asset protection doesn't make you better at being a doctor. It just gives you more peace of mind so that if something in good faith, you being a doctor, goes wrong, then you're not going to go ahead and lose everything you spent your livelihood building. But can you talk about the idea, there's the pitfalls of how long doctors tend to wait because of the nature of what they do?
Yeah. Oh, absolutely. And I put this on my quick hits at the end of items that super important to think about regarding financial planning. But if you look at a traditional, right, a traditional career, I mean, lawyers actually you can group in with physicians at this point. But if you look at a traditional career, you're getting out of undergrad at, let's call it 21, 22, right? You might not be making that much money early on, but you might start saving, and by the time you hit 30, generally you're starting to actually, let's call it, get your act together from a financial perspective, right? Maybe you're getting married, maybe you already have money in a retirement plan, you're putting money aside. As a physician, generally at that age, you're not even halfway through your training. Because you have an extra 4 years of college, very often there's a gap year to study for that, and then you also have to match as well as go residency fellowship. You're perennially behind in regards to a savings, and it is start date for the savings, excuse me. So one of the issues that comes into play is that because you're not growing money from an earlier time frame, you lose out on a substantial amount of growth because you don't have, in many cases, the ability to save. And if you fast forward, being a physician, and obviously each type of physician is different, but generally physicians have they work a little bit more. They have a little bit more of a difficult work-life balance than non-physicians. It leads to burnout. It leads to, I want to retire yesterday. It's, I want to stop getting paid for medicine and just do, work because I want to, not because I have to. So the implication that we have here is that by the time you get to that point later on, you also have a shortened working years. So as a physician, you need to save more, and you need to save more early. Now, where this comes into play in terms of the asset protection is that, unless you're making 125 or less, you can't physically save enough in a 401k for your own retirement. You have to find other ways to save. Now, you could keep money in the bank, you keep money in investment accounts, and by all means you should, but now those are the exact assets that we're talking about here as being exposed in the event of a creditor, which, again, is also top of mind. So a lot of times physicians are always looking for any sort of any asset-protected vehicles to put their money into. Retirement plans, a home in the state of New York, that's really, those are all assets that are top of mind and top of thought for physicians. And the dynamic is very, very, interesting. For the first 10 years, they're deferring any hope of focusing on their finances. But then once they get to that point, they're starting from behind. So if you set yourself up early, and I whenever I work with residents, fellows, individuals at the beginning of their career, we're focusing on just getting the right habits and getting the right items set up. So from a risk management point of view, and then also from a savings point of view, so that once you kind of graduate those training periods and then you start up as an attending, you're able to have the right habits and just continue going forward. But that's one of the interesting dynamics that I find out is that physicians have to save more than the average individual because of that those compressed working years and that delayed start. And it also leads to a tax issue, right? Physicians make more. And as a result, you have a higher tax bracket, which means your tax drag, whether it's from investment accounts or whether it's from income tax, your tax drag is significantly higher than the average person. So it leads to some interesting situations that you're put into.
Well said, Scott. So we're going to revisit a couple of these concepts that Scott touched on a little bit later in the program, right? But I want to go very quickly through some basics here. Let's talk about the asset protection of certain titling of assets. I'm gonna run through this very quickly and then call Jim in on a few different points. One, fee simple or sole ownership of any given asset. It's totally available to your creditors. There's no protection in doing that. Tenancy in common, very rare except for tax planning in certain niche situations, or in the trust and estates concept where things are bequeathed to children and the children will inherit real property, but they inherit as tenants in common by default before they reorganize into some other ownership, right? That's when you see TICs really come up. The TIC interest held by the debtor is available, but not the other TIC interest of the owners. The reality of it is that if a debtor seizes a TIC interest, they will sue for partition, they will partition by sale, and the proceeds will go to the creditor. Joint tenancy, regardless of whether or not you do it with the right to survivorship, generally you sever the joint tenancy, it's half and half. And then if you have one of the joint tenants having a creditor issue, half of the asset held by joint tenancy is available to the creditor. The exception there is joint accounts for convenience. That's in the banking law, where the true owner says, let's say, is a parent, and then you have a child who's on there for convenience. It's not the child's money, but the child is doing it as a power of attorney substitute. Not the world's greatest thing. We have a lot of clients who do it. We're not in love with the strategy, but if you have a joint account for convenience, you can prove that only the true owner is going to have it available to their creditors and not the owner for convenience. Finally, tenants by the entirety is for spouses only. Broadly, the creditor can only attach the asset if both spouses are debtors, but at the same time, if there are any cash distributions, like if you have an investment property held as tenancy by the entirety, if you have cash distributions that go to both spouses, the debtor spouse's distributions can go straight to the creditor. Upon a sale, the debtor spouse's proceeds also go to the creditor, but the risk the creditor takes is if the debtor spouse dies first, everything goes out free and clear to the non-debtor spouse, and the creditor is in a really tough situation. In New York, tenancy by the entirety is real property only. In other states, TBE is available for other assets, not New York. In New York, it's only for real property. Jim, anything to add?
Yes, very briefly. Tenants by the entirety is magic language to me. When I represent debtors, it makes my life easier. The deed must say as husband and wife. That's the magic language. Under New York law, a judgment is good for 20 years. If it's docketed against real estate, it stays on title for 10 years. If, however, the property is owned as tenants by the entirety as husband and wife, and the husband, for example, is the one that's subject to the judgment is docketed, but the property cannot be taken by the creditor. Conversely, the property owners, the husband and wife, cannot sell or refinance the property, but they can live there. The purpose of the law was to protect the innocent spouse. Now, we're going to talk about this a little later. New York also allows a homestead exemption for $170,000. Talking about asset protection planning, tenancy by the entirety and the New York State homestead exemption for the average medical doctor, professional, or business owner can provide a substantial amount of protection.
Yeah, and again, there's one little tweak to make there. After all of the legislative action at the New York State level and Obergefell and all of the different federal case law, you can have a tenancy by the entirety between spouses of the same biological sex, or of the same sex if they may have transitioned, things like that. So tenancy by the entirety is broadly available to anybody who is a spouse and in a marriage that is recognized under law. This, Jim, do you know off the top of your head religious marriages that are not secularized? I believe that TBE is still available to them, but that I don't know off the top of my head.
So 20 years ago, I had one of those cases in Brooklyn where it was a rabbinic religious marriage, and I believe it was recognized, Matthew.
To my recollection, TBE is recognized in a religious marriage. Yeah, you just have to be careful if you're going to retitle assets, right? I don't like it being titled in my own name. I'd like to title it in joint names with the spouse, for instance, right? Marital, you may commingle property. This is why doing this alongside matrimonial counsel is always going to be a good idea. You can have a post-nuptial agreement address this, but you have to be careful. If you're going to do something transferring from spouse one to spouse two, it may be out of spouse one's creditors if they're not reasonably foreseeable at the time and it's not a fraudulent conveyance. But now the transferee spouse's creditors can seize it. You have to be careful with that too. And then estate planning, right? Blended families in particular, whose will is going to govern the asset depending on who owns it. And then estate gift and GST tax issues are also a big thing, right?
And let me just jump in, and that's an excellent point. When I meet with new clients, I always tell them I'm doing asset protection planning, not estate planning. What I recommend you to do in the near term may affect your estate, so please speak with your CPA and your estate's attorney.
No question. All this stuff has to be a team approach. Team approach always works in every single legal matter, every single tax-related matter. Team approach always works. Qualified plans, right? These things are magic. Qualified plans are really, really good. For asset protection, and again, this is good for Jim to step in here. But the federal government, interestingly enough, there's a difference between a slight difference between what the federal government and what the New York State government may require with respect to ERISA.
Yeah.
And furthermore, there's a narrow set of exceptions that if you are going to, for instance, have back taxes, if you owe federal restitution, judgments held by federal instrumentality, divorce, child support, qualified plans don't protect against that. But Jim, can you expand a little bit further? Because this is really one of your bread and butter vehicles, especially for a physician, to protect assets.
Absolutely. So as Matthew indicated, 401k, ERISA tax qualified plans are golden. They are what are known as spendthrift trusts. Creditors cannot pierce them. Under New York law, you can have an unlimited amount in a pension. The question I get is called loading up. A person may or may not have had a pension. They've been sued. Can they put $250,000 or $1 million in a pension? The answer is no. It's a reasonableness standard and a look back standard. So the answer is set your pension up and fund it over time, and it is protected from creditors. And then I want to hit another good point that Matthew made. Theoretically, if you owe money to the IRS can pierce a pension. I've never seen it done. I've spoken to agents and they say that we believe it's against public policy and it's bad PR. So theoretically, if you owe taxes, the IRS agent can threaten to pierce or take money from your pension. I've never seen it happen.
Yeah, it feeds into a theme. The state government or a local government is what I would call a super creditor. They have rights to do things that a regular old creditor, a private person or a private institution cannot do. The federal government I call a super duper creditor. The federal government has certain supreme powers. They're not infinite, right? The federal government is constrained by the Constitution. They're constrained by their own statutes. They're constrained by certain guardrails, but they're not a lot. The federal government is exempt from a lot of different creditor protections that are available. And that's why we were saying before, if somebody's in trouble with the federal or the state government, you don't want to make that person's problems worse because of the enhanced powers that a governmental creditor has over you. All right, so that's an important thing to keep in mind. I'm going to do the whirlwind tour of trusts here, okay? Because we're gonna go through trusts
Matt,
quickly.
if I could just
go ahead, Scott.
If I could just step in for a quick second, back on the qualified plans, two things I just want to mention when you're looking at these. A lot of times, you know, the whole game from my perspective with qualified plans is you want to pay as little in taxes. From an asset protection, they're all good. But one of the things I always bring up to clients, two things I bring up to clients with 401ks and 403bs, those are your assets always, okay? So if something, and as you guys mentioned, they are asset protected. So if you leave your employer, if you go anywhere, that money's yours. If your employer goes out of business, that money is kept in a separate trust account that is independent of the books and the accounts of the employer. 457s are a little bit different. Okay, so a 457, if you have that on top of a 403b, which a lot of hospitals will offer, those are not asset protected, right? And while I don't think a large institution like Mount Sinai and Northwell is going anywhere anytime soon, there have been 457s that have been either assets been taken out of, and I've had clients, not at the time, but who have lost money because money has been taken out of 457. So 457s, that is a deferred compensation plan, not a defined contribution plan, which is a technicality, sounds similar, completely different. So just know that when you're putting money away, and for clients my age, I'm the age of 38, if you're early in your career, I typically, even though you have the asset protection benefits from this, I typically sometimes will steer away because while it's asset protected if you get sued, it's not asset protected if the hospital gets sued or goes into bankruptcy. So you're about to talk about trusts next. A lot of times I'll have a conversation with clients that, hey, instead of putting assets in a 457, if you're doing it for the purpose of asset protection, we'll talk about setting up a trust instead.
That's a convenient segue, right? So let me take a little bit less than 5 minutes, go through trust for a moment, because these are essential vehicles, right? If you meet these four criteria that I have up on this slide, trust will generally be off limits from creditors. Number one, the trust is irrevocable. Revocable trusts are useful, except that they are not useful in asset protection. They are useful in probate avoidance. They are useful in disability planning. They're useful in a couple other things, not asset protection. Revocable trusts have no asset protection features. Irrevocable trusts do. If the trust has a spendthrift clause, this is standard. It's boilerplate. Okay, every irrevocable trust has a spendthrift clause in it. But in the event that you don't have one, you're in real hot water in terms of asset protection. Third, trust was not funded by fraudulent conveyance. If you had a taint on the way in, the assets are going to be yanked back out. So there's no use in funding it with a fraudulent conveyance. And fourth, the debtor doesn't have any unilateral ability to distribute assets to herself, whether that's direct or indirect. And by indirect, I mean wife sets up trust for husband, right? Assuming assuming a husband-wife marriage. You have wife sets up a vehicle for husband. The distributions go to husband, but husband immediately returns them to wife. That's a circular flow of cash that a court is going to see right through. Okay, so you not only can't have direct distributions, but you can't have indirect distributions. However, a spouse can serve, a beneficiary spouse can serve as her own trustee as long as she has a co-trustee who is vested with the sole authority to distribute assets. So you can have a co-trustee arrangement as long as the beneficiary does not have the ability unilaterally to distribute assets to himself or herself. A little bit on the types of trusts that we see. Medicaid asset protection trusts, they're great for Medicaid. They protect from Medicaid. That's it. Other creditors are going to be able to get at those assets partially or fully. So you want to use Medicaid asset protection trust only for Medicaid. Spousal life access trusts. These are great because they got tax features and they've got asset protection features. So the cool thing is you have spouse one, spouse two. Spouse one sets up a trust for spouse two, right? Spouse two is the beneficiary. Generally, you can protect the assets from the creditors of both spouses as long as you run the trust correctly. Beneficiary spouse doesn't have the ability to unilaterally withdraw and all the other things I talked about on the previous slide. A family trust, right? Now you've got not only the spouse as a current beneficiary, you may have children, right? Children could be included as pooled beneficiaries. Again, if administered correctly, generally protected from the creditors of grantor, beneficiary, and trustee, right? I got an example in here that we don't have time to cover today, but you can look at it and there's enough details in the slide that if you read through it, you can see how much customization there is in spousal trusts and slats. They're very cool. They're very flexible. We use them in tax and asset protection planning in our firm all the time. And it's because they solve so many problems. It's a versatile tool, and you should really take a close look at using them. A brief bit on domestic and offshore asset protection trusts, okay? The next slide talks about the UVTA. I'm going to cue Jim back in when we talk about the UVTA. But domestic asset protection trust, that when we put the deck together a while ago, it was 13 states. Now I think we're up to 21, okay? The closest state to New York is Connecticut. New York is not a DAPT jurisdiction. What is a DAPT? You set up a trust for yourself, but you still get asset protection benefits. The most popular jurisdictions are Nevada, Alaska, and Delaware. You may throw South Dakota in there. South Dakota is very, very popular. It's the Cayman of the Midwest, and it earned that nickname, all right? When you go to these states, if you set up a trust for yourself, you can set up a trust that you benefit from, but is protected from your creditors as long as you have not funded the trust with a fraudulent conveyance. Powerful, except if you're a New York resident, for reasons we're going to go into on the next slide. I don't think it works, and I think Jim would agree it probably doesn't work. Offshore, you really don't want to go offshore for two reasons. One of them is if you really want to do this, do it in the good old US of A. And the second reason is even though people make certain comments about the full faith and credit clause and talking about how one state's got to honor the judgment of another state and this and that and the other. Offshore, there are so many, first and foremost, the optics are horrible. They're horrible. I mean, the minute that a judge sees them, in my experience, they know what the game is. And they're going to start doing things like, if you want to go look up a United States judge who really frowned on one of these, go look up Kevin Trudeau. who did all these like cures you don't want to know about and that sort of business, except the FDA and other regulators came after him and said, you can't even do this. Trudeau owed a multi-million-dollar judgment to a government agency. He had a trust that was in, I believe, the Cook Islands. And then he turned around to the judge and he said, I can't give you anything. I can't give this agency anything. All my assets are in a trust in the Cook Islands. And the judge turned back around to him and said, Mr. Trudeau, I'm going to give you two choices. I'm going to throw you in prison for 10 years for contempt, or you can part with the assets. Mr. Trudeau chose to keep the assets but give up his freedom. You do not want to put yourself to that choice. Or you go offshore and the judge knows what's going on here. So you really don't want to give yourself that type of situation. In addition, you have to hire a trustee locally. That comes at a significant expense. And in New York, I say if you want to use it, you can make it what's known as a synthetic prenup, meaning if you put assets in there before you're married and you never commingle them, it's nice to have a built-in isolation of those assets. But that's about all I use them for in New York. Jim, you want to talk about the UVTA and whether or not the UVTA definitively tells you you ought not to do this if you're a New York resident?
So I do, but one more point about offshore trusts. They're also a tax audit issue. If you check the box on a 1040 and it says, do you have an offshore trust? You're much more likely to be audited, which is another reason.
Yeah, there's a great point, right? The FATCA issues. You may have missed your calling. You may have missed your calling going into tax, putting that LLM to good use. But talk about for a second the UVTA.
All right. Before I talk about the UVTA, I want to talk about the Uniform Fraudulent Transfer Act. There are actually two laws now. Life has become a little more complicated. The prior law was the law most of us know, and that has a 6-year look back. New York State passed a new law, the UVTA, the Uniform Voidable Transactions Act. The first point is it's a 4-year look back rather than 6, which is positive. However, it says that if you set up a trust, a domestic asset protection trust outside of the state, and many of my clients went to Nevada for many different reasons, and Alaska, jurisdiction is still in New York. So as Matthew, Scott, and I have discussed, there's a question mark now of whether out-of-state asset protection trusts work with the UVTA, and I would be skeptical and concerned to advise a client to do it now. I agree with Matthew.
Excellent. Okay, whirlwind tour of corporate entities. It's about, okay, so it's 11:53 Eastern time. So we're 7 minutes with our allotted. We may go to 5 after or thereabouts. So if it inconveniences anybody, we do apologize. But at the same time, there's a little bit of information left and we want to make sure we cover everything. Whirlwind tour of corporate entities like we did with trust. These are my own terms, by the way. This is what I call them. I call them upstream and downstream protection. Upstream protection says, I have an entity. The entity is conducting activities. There is liability there's liability arising from the activities conducted inside of the entity, right? What is the main concern there? Piercing the corporate veil is the term of art for it. Downstream protection says, I have an entity and there is some unrelated liability that goes against the entity's owner. What's the main concern there? The main concern is that they're going to take the equity from you, right? What types of protection does an entity offer in both scenarios, upstream and downstream, right? When you have upstream protection at stake, what do you want to make sure is in place? Number one, all your adequate books and records. This seems mundane, except for the idea that some of this is required by law, especially if you have a corporation. In New York State, the business corporation law says you got to keep minutes of meetings, you got to meet every year, right? You got to appoint officers. You got to do all sorts of other things. If you have an LLC, you're required to have an operating agreement. And then in certain scenarios, sustaining a lawsuit or prosecuting a lawsuit, you may require publication, which is annoying and expensive, except for the idea that you need to do it. These formalities are important. Always act in a corporate capacity. If you are conducting your hardware store out of Joe's Hardware Store Incorporated, you are operating as the president of Joe's Hardware Store Incorporated, not as Joe Schmo individually, right? The minute you hold yourself out as an individual, you jeopardize this. Do not commingle your assets, okay? Corporate bank accounts, corporate credit cards, paying corporate expenses. You are not funneling personal funds, personal activities, and those sorts of things through your corporation. That's going to sacrifice your protection. You can make paid-in capital contributions, that you can do, except that they are permanently now the property of the corporation and not of you. Make sure your activities are adequately both capitalized and insured. Jim talked about this when he talked about fraudulent conveyances. Not only do you need an adequate balance sheet in order to carry on your operations and pay your debts, you need adequate insurance for reasonably foreseeable things. You don't need insurance to cover everything, but you need it to cover a lot of things. And anything that you think could conceivably come up in your business, you should be covered for. When you're a doctor, malpractice, always, no exception. Doctors are better at this than lawyers. Lawyers and accountants are sometimes practicing naked, and that will bite you every single time. If you're a licensed professional, you get errors and omissions insurance, period. When it comes to downstream protection, okay, downstream, you want to make sure that your agreements are put together the right way. You want to make sure that you have multiple equity holders. You want to make sure that new equity holders can only be admitted by unanimous vote. If they're not admitted, they're mere transferees. They get the economic rights, meaning the distributions and any sales proceeds, but they don't get rights of governance. You do not want them to vote. You don't want a person who seized their equity by force to be able to vote. Otherwise, if you do this correctly, you're limited to a charging order. All distributions that would come out from the entity are going to go to the creditor, and they're not going to go to the original holder. But at minimum, it makes sure they're not going to be able to get to the underlying assets of the entity. And that's really what you're looking to go toward there. To make a charging order less attractive, don't make your distributions automatic. You have to declare your distributions by people who can vote, okay? So you have to have this all under control of people who can vote, and then you have mere transferees that can't vote, so that if you're setting this up correctly, there's no ability for them to be able to forcibly bring the assets out of the entity and into their own possession from the creditor perspective, right? Automatic buyouts for triggering events. We have on our resources, on our YouTube page, and other publicly available places, we have our business succession presentation that talks about this in detail. But we listed some triggering events here, some of which are creditor events: divorce, insolvency, bankruptcy, you commit a crime, bad behavior, commission of a tort, loss of your license. These things should trigger automatic buyouts, okay? So that you have the ability to set a fair market value by agreed upon mechanism, go ahead and buy out the person who has creditor issues so that none of this screws up the greater enterprise, all right? Because otherwise, if you don't have this stuff, creditor steps in the shoes, they seize the equity, they have votes, and you have all manner of problems. Really brief notes on types of entities. Sole proprietorship, you're naked. There's no liability asset protection at all. No upstream liability shield, no downstream liability shield. General partnership, now multiply that, right? Upstream protection doesn't exist at all. If the general partnership incurs liabilities, all the partners are on the hook. But in general, if one partner has a creditor problem, you can't seize the assets of the partnership unless the creditor is of the partnership or of all partners. Limited partnership. General partners got unlimited upstream liability, but downstream liability is still there. Limited partners get both upstream and downstream protection, which is one of the reasons why LPs are nice and people still use them. Corporations, upstream and downstream protection are both excellent, regardless of whether you're an S Corp or a C Corp, regardless of how many people own them. LLCs, excuse me, I'll elaborate a little bit in a minute, but LLCs in general get upstream and downstream protection both, but there are nuances to single member LLCs that I have in here. And for tiered entities, right, if you combine some of these with entities owning each other, you have to evaluate liability separately at each individual tier. Professional stuff, right? Doctors are going to have PCs, they're going to have LLPs, LLLPs, PLLCs, all that stuff. The only difference with these is that you cannot protect against your own individual malpractice liability. So if you are a doctor and you're in practice with 4 other doctors in the same specialty, you commit malpractice, your partners are protected from it. That's the nice thing about having the professional entity, but you're not protected from your own, right? And the business is not protected either, but the business is there to make sure that only the business's assets are available, not personal assets. Downstream liability, it's really almost never a concern anyway, but that's the difference there in what a professional entity does. But a lot of people shrug their shoulders and say, why am I going to set up a professional entity? The answer is, for everything that's not a professional liability, you get your upstream protection, so you have to do it. I'm going to turn it over to Scott for one moment, and Jim will step in as well to discuss insurance and annuities from this perspective. But in addition, in case we don't get to it, make sure that you have insurance for every conceivable liability that you could encounter. By that, I mean, you know, things like general commercial liability insurance. And we have a list of these things. So don't forget those, even though malpractice is the most prominent among doctors. So from here, let me have Scott go ahead and talk about insurance and annuities and
Sure.
what these can do in order to enhance your asset protection.
For sure. So, you know, I'll start off from, you know, from my end. The next couple of slides are going to go through specifically some of the pros, cons, and kind of go into a little detail on the individual products. But one of the best advantages of insurance is that you can use insurance, annuities, all of which as asset protection vehicles in terms of where you put your assets. Depending on what type, also, you can either have market upside or you can have fixed guaranteed rates. So what New York State, and New York State's not the only state to offer it. New York State is actually better than quite a few other states from my experience. But the asset protection that you have within those products for cash values do make them viable options for physicians and any business owner, really, in order to grow their assets. Jim, I'll turn it over to you from your experience on the bankruptcy end. How often do you feel, or how good is the protection that's provided to insurance and annuities in the state of New York?
So by statute, $5,000 of annuity are protected, or a greater amount that you need for to take care of your family or to live on. I generally do not advise clients to go crazy or to overbuy annuities. However, with insurance, cash surrender value is outside of the reach. It's asset protected. So most of my clients have term insurance because it is cheaper, and term insurance has no use to a creditor or a bankruptcy trustee. So term insurance is automatically okay. Any other type of insurance, whole life with a cash surrender value, is wonderful, provided that you can afford the product. But cash surrender value is forced savings, and it's exempt.
Now, one other question. What about disability insurance payouts?
It's generally exempt.
Okay. If you can go to the next slide, Matt. One of the biggest topics I talk to physicians about, and it usually starts early in their career, is making sure that they have the adequate disability coverage. You know, with the way the market is for physicians now, especially, is you'll go from one job, you'll go to another job, and your benefits change when you go from one place to another. If you have your own practice, hopefully you're not going anywhere. But the way medical practices and larger hospitals have brought up individual practices, it's very often that you will or do change employers as time goes. So your group benefits, whatever you get, are generally not portable, which means you can't take them from one place to the other. If you work at a large institution, you go to a private practice, that private practice may not have group coverage, you're left with no coverage. So it's very important as a physician to have your own private policy that you can take with you from place to place. Also, what's very important is to understand within the contract what defines a disability. Within a disability insurance contract, most group have some sort of definition called any occupation, which the language generally reads for which you're considered totally disabled if you cannot do any occupation for which you're reasonably fitted by education and experience. Now, the actual language usually will change a little bit from there, but you can kind of copy paste that. And most group plans, if it doesn't happen immediately upon disability, it'll happen with 2 to 5 years, which means that if you can work in another capacity but not as a functioning physician, that's not a total disability. Your benefits are either going to be cut or reduced. Now, typically for a physician, you need some sort of occupation-specific coverage. Now, I use that term because own occupation is the one that you see the most. However, a lot of times physicians don't need necessarily own occupation, because what constitutes an own occupation, usually there's a little bit of a discrepancy. But either way, you need something that's better than any occupation, of which a group plan doesn't give you. Group plans generally have offset provisions, meaning that if you receive income from certain areas, it'll reduce the benefit. What constitutes a disability usually comes from your billing codes. So if you're, I usually use orthopedic surgeons as, the ones that I pick on for this. But, a lot of times when you ask them what they do, they say they do surgery. But the reality is that, I've seen an orthopedic surgeon 3 times for my knee and I've never had surgery, right? So they're billing each time. And anything you bill, even if it's patient consults, all of that comes through. So when a disability insurance company, either group or private, looks to see how you're going to get a benefit paid, they look and see what you've billed over the last 12 months, and that's what they put as your occupation. So if you're doing surgery 50% of the time and you can't do surgery, but you're working and you're planning to continue doing patient consults, you're not totally disabled, you're partially disabled. And then also understanding with disability insurance, 2 big things. Number one, because you're paying for it privately and it's not outside the scope of your employer, generally the benefits are going to be tax-free. So if you're at a group and you get $10,000, you don't actually get $10,000 because your employer is paying for it. They're taking the tax deduction. That $10,000 comes to you after taxes. But if you pay for the premiums, it's generally a tax-free benefit. And then the biggest thing is ratings matter. I work at Northwestern, which is one of the highest rated companies. I do a lot of business outside of Northwestern as well. But the one thing I've seen in going through disability claims with clients is that the quality of the company matters, because if you read the definitions, they're very gray. They're built that way actually so that the companies can apply them to many different situations, but that also becomes double-edged sword when a company doesn't want to pay out a benefit. So you want to go to a company that has high financial ratings, and there's a reason sometimes why it's more expensive to do that. But ultimately, because it's a world of gray, you don't get a certificate that says, like you do with life insurance, where it says, hey, so-and-so passed away. You don't get that with disability. So having an actual high-quality company is very important. I typically will always go to the mutuals when I'm looking at disability. Now, if you go to the next slide, going through the main benefits of on the life insurance side. Matt, if you could just, there you go. Number one, you buy life insurance because it's a death benefit. Now, the death benefit typically comes income tax free, right? So I see a lot of physicians looking to purchase real estate. They purchase, properties, and I'm not going to talk about step-up in basis. I have 2 lawyers on the call who can do that, but a lot of assets will get a step-up in basis. But with life insurance, you don't have to worry if that rule changes, right? Which was, I believe, on the docket to be changed. With life insurance, that death benefit is income tax free to its beneficiaries. Okay. When you're looking at the cash value side, it's best utilized as a long-term asset, but it could be accessed in a tax favorable way. When we're doing investment planning with clients, if it's in a non-qualified account, it's generally exposed to capital gains or short-term capital gains, which is also income. If it's in a trust, the level of capital gains or income is actually higher than it is unless you are at the highest U.S. tax bracket. So trusts have higher tax levels. So if you're, let's say, at an income of $250,000, $300,000, you're not at the highest tax levels, although it may feel like it. If you're in a trust, those are also taxed, but even at a higher level than you would had you been making that salary. And not to say you shouldn't do it, because you do get these asset protection benefits, but with life insurance, you can access that money in many cases tax-free, and it's guaranteed to be tax-deferred. So your tax lag, as we call it, which is what you pay and how the taxes that you pay on the growth of your investments affect the overall growth over time, is significantly less. Now, with life insurance, there's 2 different types, right, of permanent life insurance. You could have a variable style where you can actually invest alongside the markets, whether it's the bond market, stock market, whatever. You can customize it, and that's going to grow almost as fast as an actual investment account. And I say almost because you do have the cost of insurance on it. And then you can also look to invest into something more fixed, right? And then you can also structure the premiums in various ways, where if you have a large upfront cost or you have a large upfront amount of money, you can put that in as a lump sum and then put in less later on. You can fluctuate or create flexible premiums, or you can have a fixed guaranteed cost. Depending on your circumstance, you may prefer one or the other. Business owners, we usually do flexible. And then with individual W-2 employees, we're going to talk more so with a more fixed payment. Now, the cash value is liquid and can be accessed in a matter of days. There's no make to market on it, as we say in finance, which means you're not getting what someone else is going to pay. The value is what it is, and that's what you're going to get. And usually, it can, depending on the product, it can come to you almost overnight or within 2 days. And then once the death benefits are triggered, that's the other benefit, is that death benefit with a death certificate gets to you within 7 days. If you hold assets in, let's say, property is the biggest one, is that you buy a rental property, you say, I want to give this to my kids. If they need to sell it, if they have tenants that aren't paying, or if you're not there to kind of show them how that works, that's a very difficult asset to get money out of. You have to sell it. And, real estate transactions can, at the best, take 3 months. At the worst, take a hell of a lot longer. With death benefit, it gets to you in 7 days. So the flexibility and the quickness, and there is a value to that. Now, if you go down to the next slide, annuities are essentially a form of insurance. What they are is an insurance company providing an investment vehicle. Now, there's two basic types of annuities. The first is you're going to pay me. That's called immediate. That means you're putting in a lump sum of money and you're getting an income stream. Okay? A deferred annuity is one in which you contribute a lump sum of money with the expectation that at some point in the future, you're going to receive an income. Now, those are the two different basic types, but the investment aspect can be broken up into two types as well. One is a fixed annuity, which, to be frank, I probably haven't sold in about 10 years. In a low interest rate environment, it's not really the most attractive thing. But a variable annuity, again, is very similar to variable life insurance, where you can invest money, get almost the rate of return that you would in an equivalent investment account, but you get these asset protection benefits as well as you get tax-deferred growth. Now, one quick note about variable annuities, I am relatively careful with them. A lot of people who we look to an annuity for, we typically make sure they either have significantly high income, because when you take money out of a variable annuity, it is income taxes. Whereas if you're investing and you know what you're doing on the investment end, very often through stock investing, you're getting capital gains. Right? So there is a little bit of a tax discrepancy because income's higher than capital gains at almost every bracket. Okay? I'll turn it over to you, Matt, on that end. Is there anything additional that you feel I should add, or from an asset protection?
So
how do you feel that, these are?
The direction I was going to take it from here is I was going to round up, because we have kept everybody an extra 15 minutes. So I wanted to make sure that we could round up with some general principles, because a lot of the stuff that are in the next 5 or 6 slides is really miscellaneous, and it can be digested if folks read the materials. But what I want to do is we got some basic principles in here that are just stuff to round up what we've gone over today, right? Number one, if you're in the medical business, you want to have ample insurance, malpractice insurance, car insurance, home insurance, umbrella insurance. You also want to make sure that you look to life insurance, which, as long as you have somebody like Scott implementing it for you, right, who's a veteran in the industry, knows what he's doing, understands the product offerings, and understands the different features of what it can offer to you, it really is the closest thing you've got to a magic bullet. Qualified retirement accounts, they're amazing. They're asset protected. They have tax benefits. You should always use qualified retirement accounts to the fullest extent you can. If you believe that annuities are going to be right for you and you're advised by the right person, you go ahead and you put some annuities together to supplement the other measures that we were talking about. Irrevocable trusts, they work very, very well. We talked about those briefly. You want to make sure you're practicing through an entity, and you gift or you transfer assets sometimes through trust, right? And then, as Scott was going over, from a financial planning standpoint, right, even when it comes to the legal sometimes, Timing is important. The best time to plan is now, generally, because the situation can't possibly get better if you're not being pursued by creditors. Make sure you diversify, right? And this is, go ahead, Scott.
One quick add on the timing is that's especially important for the insurance end. Insurance is not sexy, nor is it fun, but you're not always guaranteed to be able to purchase insurance. And that's a fact that a lot of times people forget, is that it's based upon your health. And if your health isn't good, or as you get older, the cost of the product actually goes up as well. So it's very important on that end to make sure you get it early.
Interesting story. That is a nice thing to wrap up about, right? I had a client who had secured actually insurance. She secured $2 million of death benefit, and it was permanent. The client then had 2 adorable twin girls born prematurely, and they had certain medical issues they would need to be cared for, and he needed to increase his insurance limit. He delayed a little bit. He delayed because of how much was going on when the twins were born, and it turned out that during his delay, he was discovered to have a fixable heart condition. So given that the heart condition was fixable, he was lucky that he would later qualify for insurance, but he would need to wait 5 years to reapply to make sure that after his surgery, he was in a stable health situation. So again, best times now. Asset protection, financial planning, insurance implementation, the best time is always now. So we hope that's a nice call to action. And again, Scott, we got an extra R in your email. That's our fault. We apologize. Oh my goodness. Scott's name has one R. Okay. Can we, Abby, can we circulate this in the everyone chat to make sure that everybody's got the correct email address for him? Okay. But all of our emails are up on the screen, noting that Scott has one R in his last name. All right. And if you'd like to reach out to any of us to further discuss the concepts that we have explored today, you can always feel free to do so. Thanks a lot for tuning in. We appreciate all of you joining us, and we hope that this presentation was informative. Everybody take care. Enjoy the rest of the day. Stay safe out there.